All right. Well, welcome to another live. This is Albertson Davidson live stream, Real Lawyers, Real Answers. And we have some exciting news today. In the world of trusts and estates, we very rarely have super exciting news, especially from the California Supreme Court. But today we do. So there's been a case that has been causing all sorts of consternation for all trust and will people throughout the state called Barefoot versus Jennings. And today, the California Supreme Court actually came out with a ruling and overturned the appellate court that had said that people who were not current trust beneficiaries of a trust could not contest a trust in probate court. And so the appellate court effectively, had that opinion stood, would have effectively dismissed, hundreds of thousands of cases possibly in the California probate court where people are suing to overturn trust amendments based on things like lack of capacity or undue influence. And the problem is that a lot of times when you bring a trust contest suit, you are not presently a beneficiary. That's the whole point. You've been disinherited. That's why you're contesting the trust. And you're trying to get an amendment to be overturned so that your rightful place as a trust beneficiary can be restored. And so am I kind of describing that properly, Stuart? I feel like I'm struggling a little bit on this.
You're struggling quite a bit, but let me jump in here and see if I can help out. So, I think it is big news. And here's the issue with Barefoot is that the appellate court they got this so wrong.
Right.
And I think most practitioners, or at least the majority of good practitioners in this area, knew that they got it wrong. And essentially what they did is there was an argument that the statute in the probate code 17200, it describes the kind of people that can file a let's call it a lawsuit in probate court. It's called a trust contest, and it's to invalidate a trust amendment that was signed maybe on the midnight before somebody passed away, and somebody was an original beneficiary of an original trust, and now they're out under the amendment. And the language in the statute says that beneficiaries and trustees can come to the probate court and say, "Hey, probate court, help me resolve my problem." And so there was an argument by some lawyer, and that's how we got the appellate opinion in the first Barefoot, and that was, well, if you were a beneficiary, but then you're thrown out under a subsequent midnight amendment, you're no longer a beneficiary, and therefore you don't have standing, we call it standing, to bring your claim to the probate court.
Right.
And Judge Cowan, who is one of the best judges in Los Angeles in the probate court that we're around, he made some comments on Barefoot in some of the cases that were before him at the trial court level. And the point he made was it doesn't make sense that if you're in a trust and then you're taken out of a trust but given $1, that you would have standing to contest the trust amendment that kicks you out. But if you were in an original trust and you got completely thrown out and it didn't even get $1, you wouldn't have standing to come in and ask the probate court to resolve your claim.
So what that suggests then is what the appellate court was effectively doing was saying, if you're not named in the last iteration of the trust, so you take the trust and all the amendments, and if you're not in that last amendment and all the other amendments, that work at the date of death, you cannot file a lawsuit under 17200 to challenge.
Okay, but if you were getting $1 under that amendment,
then you could.
Then you could.
You are a present beneficiary under all these documents.
That's right. Yeah.
But it kind of puts the problem with that is it puts the cart before the horse, because the whole reason I'm even suing in the first place, if I'm a disinherited person, or even if my interest was cut down. So let's say I was going to get 50%. Now I'm only getting 5%. Well, the reason I'm suing is because I'm saying that final amendment is invalid. It's not an amendment. And yet the court, under the appellate court's version of Barefoot, is saying, we're just going to assume that final amendment is valid before we even had an adjudication on it.
Well,
and therefore, because of that, it's going to keep you from being able to sue.
That's right. And the way we viewed this case, and we would struggle with this internally, is look, if you were in an original trust, and let's say you were getting $1/3 of $1 million, and then right before grandma dies, 2 minutes before she dies, she makes an amendment and completely disinherits you. When you attack that amendment with a trust contest under Probate Code 17200, you're a contingent beneficiary. You have a future interest in the trust, because if you're correct, if your recitation of facts is correct, and you win that case, you win that trust contest, you in fact are a beneficiary.
So it's contingent upon you winning the lawsuit.
That's right, but you would be a beneficiary of the trust. So I think that I'm glad 12 pages in the opinion from the California Supreme Court, which you rarely see them do a 12-page opinion. I mean, this was a very simple matter. They knocked it out of the park. And now the beautiful thing for us as practitioners is all of those lawyers that we've opposed on the other side that were representing bad people that had gotten changes at the last minute to their mom and dad's trust or grandpa and grandma's trust, they're no longer protected and insulated by the appellate opinion in Barefoot that says, aha, since you're no longer a named beneficiary of the amendment, you can't challenge it.
So let's talk a little bit about what was the problem here. So let's say that the appellate court decision stood that said, if you're not named in the final amendment, you cannot bring a lawsuit under section 17200 to challenge the trust. What did that leave? What was the result of that? Where would somebody go to challenge a trust?
Well, it's not where would somebody go. Let's talk first about is a bad social policy, and that is who does that protect? Who does that decision protect? It protects bad acting people.
Yeah, whoever actually got the final amendment.
Yes. Yeah. Yes, so that's a problem. And so then what you're left with is doing an 850 petition, which is under another probate code section, but that has to do with the transfer of property to a trust, and it may not be a perfect fit for all trust contests.
The other thing we struggled with is, can you file just a regular civil complaint in civil court to challenge a trust?
And it seems to me that if Barefoot stood, the appellate court Barefoot stood, and somebody who is completely not named in the amendment and they're out and they don't have standing under 17200 to file a trust contest like we've been filing for the last 20 years in probate court, then yes, your recourse would be go to civil court and demand a jury trial.
Right.
And have a jury trial on a trust contest. But you'd be using the Civil Code 1575 definition for undue influence versus what you would use if you were bringing a trust contest under 17200.
So then you'd have a situation where a trust matter is being heard in civil court when the probate code says that the probate court is the exclusive jurisdiction for trust matters.
That's right.
And you have a situation where the civil court is going to use a jury trial, whereas in probate, it's always bench trial.
Which I would have been happy with that because I would like to do jury trials on these cases, but I'm glad that think about all of the consternation this has caused for many practitioners. And the problem, I think, what we were so frustrated about is we all knew, or most of us knew, that we were right, that this was just a bad outcome on an appellate decision. And I'm so glad the California Supreme Court they grabbed it up, they did all the review and hearings, and everything was filed in front of them. I think there was a lot of supplemental briefing on this case by different people with different interests. But ultimately, the court got it right and says, look, everybody has a right to make a claim that a trust amendment is invalid if you were previously named in a trust instrument. Let's think about it. If there's an original trust and there's 40 amendments and you're not named in any of those 40 amendments, under this petition now, you have a chance to attack all 40 of those amendments because you were named in the original trust.
Right. That sounds like a nightmare, challenging 40 amendments.
You wouldn't want to do that. Yeah, you wouldn't want to do
that. The Supreme Court focused on a section of the probate code that Judge Cowan in Los Angeles also focused on, and that was probate code section 24.
That's right.
Which is a very simple probate code section. It's under the definitional section.
Defines beneficiaries, right?
Defines beneficiary, and it defines a beneficiary as a person who has any present or future interest, vested or contingent.
Contingent, future interest in a trust is what a person has if they're not named in the final amendment.
Because that final amendment may or may not be valid. And if it's invalid, then you are a beneficiary. If it's valid, then you're not a beneficiary, potentially.
It's something that you had talked about, and I didn't quite understand what point you were getting when you first read the opinion, was that, look, let's step away from the trust and estate world for a second and look at civil procedure, just plain Jane rules applying to lawsuits in California. When we file a lawsuit in court, there's our general rule that when we file something, that whatever we've said in that application or petition is true. And the other side can attack the truth of the matters we've stated, but they can't say, oh, no, you're wrong. That's not really how it went. That's for a trial down the road or for some type of later motion, like a motion for summary judgment or adjudication that's way down the road when you're talking about who's right and wrong. But at the outset of a lawsuit, anything I say has to be accepted as true. How did the Supreme Court in Barefoot address this issue?
And that's a really important point because with Barefoot, it was decided on a demurrer. And a demurrer is something that attacks the pleadings at the very outset of a lawsuit, very beginning. And what a demurrer does is it just says, well, even if everything you say is true, you haven't stated enough to state a cause of action under the law. it's a very technical thing. I mean, it doesn't make a whole lot of sense outside of us, in the lawyer world. It makes some sense, but outside the lawyer world, it doesn't make a whole lot of sense. So anyway, what the California Supreme Court said here is that, look, if you're going to toss a lawsuit out right off the bat on a demurrer, you at least have to look at what the allegations are, and you have to take those allegations as true. So if I come in and I say that last amendment's invalid because it was obtained through undue influence, the court, in making its ruling just on the demurrer stage, not later on in trial, for the demurrer, the court has to assume that my allegations are true. And if it's true that the last amendment is invalid because of undue influence, and as a result of that, it's going to get tossed and I'm going to come back in as a beneficiary, then the court has to assume that to be the case. And therefore, I am a beneficiary under the definition of Probate Code Section 24, because I may actually be a current vested beneficiary under that scenario, but I am a beneficiary of the trust. And I think what was so troubling about the appellate court decision is they just assumed the opposite. So they assumed that, in fact, that last amendment was valid. You are not a beneficiary, and therefore you have no standing. And it's just kind of, it boggles the mind if you think about it, because even on any lawsuit you ever see almost, let's say you just have a personal injury lawsuit, as a plaintiff, I'm going to say the defendant was negligent. The defendant's going to say, no, I wasn't. Why would the court assume that the defendant's right off the bat?
Right.
Or assume the plaintiff's right for that matter?
Right.
I mean, it makes no sense.
Right. Well, and that gets also to the social policy aspect of this, that if Barefoot, the appellate court, has stood, you're really protecting bad actors, people that come in at the last minute and get an amendment to a trust. And in that amendment to the trust, they make sure that nobody else is named. And therefore, you can't challenge this under 17-200.
So to people who aren't familiar with this area of law, either you're not a lawyer in this area, what does this really mean? What's the bottom line for this ruling under the California Supreme Court for just regular people out there?
Well, it gives you comfort to know that you have a gateway open to you, a door open to you to the probate court, where if someone removes your name from a trust, you have a right to come in there and contest whatever document it was that removed you for undue influence or lack of capacity or duress or menace, where the decedent in that case did not intend to take you out of the trust. Someone else helped the decedent take you out of the trust, and you want to have your day in court to prove that's what happened. Now you have that ability in what we call standing. You have permission, essentially, to stand before the probate court and say, I have a valid cause of action. Here it is. Now I would like my day in trial, which is down the road. But just getting past that threshold of, do you have a right to bring this lawsuit? Barefoot Supreme Court law of California now says you have a right to bring your trust contest.
And how shocked do you think you would be if you didn't practice? You're just a client off the street and you came in and I said, well, it's really nice that you were disinherited and all that, or it was terrible that you were disinherited, but you don't even have the right to stand before the court and sue.
That's right.
I mean, that'd be shocking.
It'd be shocking. Yeah. And also, what was the recourse? And you think about, the California Supreme Court it made the right decision here from a consistency standpoint and looking at the statutes and so forth. But let's just look at the opposite side. Let's say the Supreme Court had found the other way. What happens to the civil courts who are already overburdened with all of the cases they have? All of a sudden, you're going to have this flow of trust contests coming into their court system. Oh, yeah. And that's why, when we talk about the civil court and the probate court, we need to be clear in California. Probate courts are courts of concurrent jurisdiction, meaning they are a superior court. They're just as good as any other civil court in the land. However, you have to have some probate matter initially before them with standing before you can have all the other civil causes of action heard at the same time.
Right.
Whereas a civil court, if there's no probate matter whatsoever, you're going to go to the civil court if it's a civil matter, and you're going to file it there.
Right.
So now this has cleared up a lot of issues for us. We all know we're okay in probate court, where we should be. You've got the judges that understand trusts and probate that are going to be hearing these matters. And so at the end of the day, everyone should be happy.
Well, and it's interesting, too, because I've been practicing law for almost 20 years. You've been practicing for a similar amount of time. We've been in partnership for over 12 years. Just in the time that our firm has been in existence, we have filed hundreds upon hundreds, maybe thousands of trust contest cases under 17-200. Courts have taken those cases, processed them, made decisions based on them,
Yep.
rulings based on them
Right.
for years and years and years.
Yeah.
And now all of a sudden you get this ruling by the appellate court saying, oh, no, you can't do that.
Yeah.
I mean, it's just
Yeah. Well,
shocking.
you can do it, but only if you are a beneficiary
Yeah,
or a trustee.
right. A current one in the last, it's
So something
it's
interesting, I
massive.
wanted to throw this past you because most probate courts are going to require us to attach as an exhibit the trusts in this case. So let's say we have to attach the original trust showing that we're a beneficiary, and then we attach the amendment and it shows we're not a beneficiary. I don't think there's anything in the Code of Civil Procedure that says you must attach a contract or a trust or anything else to a pleading if you choose not to.
That's right.
So I wonder, could we get around this? Let's say the California Supreme Court hasn't come out yet on this hearing today. We're still in this area. We're not sure what the courts are going to do. Why couldn't we just take the court's opinion on Demurrers, where you have to accept my pleading as true, just plead that I'm a beneficiary of this trust? I mean, would the court have to accept that?
That would be interesting. I mean, the problem we have in probate is it has to be a verified pleading, so it has to be true.
Right.
But I guess under the contesting beneficiary, you'd be saying, well, it is true.
It is true.
Because that final amendment is going to fall.
Once I kick the crap out of this amendment, I am a beneficiary.
Right. Yeah. I mean, that's an interesting thing. Also, what happens if you have the final amendment? Because let's say it's a restatement or something, or you're disinherited, but you don't have the earlier document.
Right.
Then obviously the best you can do is just plead on information and belief. I believe that I was named in the earlier document.
That brings up a really interesting point of this, and that is that many times there are restatements, right?
Yeah.
And a restatement, if you think about it, once somebody passes away, the only thing that the trustee of the trust after the decedent passes away is required to give to all heirs and beneficiaries is the final pronouncement of this individual.
Right.
And that if it's a restatement, which is stronger than an amendment, it's essentially redoing a trust, then they are only going to provide you with the restatement. They're not going to provide you with any previous amendments or any previous trusts.
Yeah.
Now, of course, we know we get those in discovery,
Right.
but
You have to file a lawsuit.
You have to file a lawsuit, yeah.
Yeah. It's a big problem, too, because when cases come in and people can't get the earlier trust, it really puts us in a situation where you're almost forced to file the lawsuit. Now, what we hear is by a lot of kind of estate planning attorneys or trust administration attorneys is, I don't want to give you the earlier version of the trust because if I do, then you'll file a lawsuit.
Right.
And yet, from our point of view, it's just the opposite. It's like, no, if you give us that, we may not file a lawsuit. But if you don't give it to us, then we most definitely will file because we have no choice.
And we're going to get a copy of that trust. Like we have a case now where there's a heavily redacted trust that's been provided to our client. Heavily redacted. It's like a CIA top secret thing, right?
Right.
It's just redaction after redaction after redaction.
Right.
And the person's dead that created the trust. We
Right.
have a 100% right to the entire trust.
And we're going to get it. And now we're going to file a lawsuit to get it because we have no choice. Whereas if you would just give us the unredacted version and we could see it, it might be that we say, oh, this isn't worth filing on. I don't know.
That's right.
So one of the quotes from the Barefoot case that I thought was interesting, and you pointed this out, Stuart, when we were going over the case earlier, is and the California Supreme Court is quoting from Estate of Bissinger, which is a 1964 case going way back.
That's when you were born, 64.
Not quite. No, it was a little after that. And it's making the point that the court has observed as a general matter that the probate court was intended to broaden the jurisdiction of the probate code. Pardon me. The probate code was intended to broaden the jurisdiction of the probate court so as to give that court jurisdiction over practically all controversies which might arise between the trustees and those claiming to be beneficiaries under the trust.
That's right.
And that makes perfect sense because where else would you have those disputes? Where else would you have those lawsuits if you're not having them in the probate court, which is supposed to be the court of exclusive jurisdiction over trust matters?
Right.
And so it was a complete and total disconnect to not be able to do that.
The next sentence, too, I think was important, and I don't remember what it was, but the wisdom of those decisions from 1964 have not lessened
Over time.
Right. I mean, I think that's such a powerful, and used to, Keith is a master at using cases from 1917 and 1880 and things
well
like
established.
that. Yeah, and his argument is always, we have some well-established law here, Your Honor.
Yeah.
Long-held established law. So.
Long decided.
Yeah.
Because a lot of times there is this idea that a case from long ago doesn't seem like it carries as much weight as a case that's more recent.
Right.
But that's not true, actually. I mean, Marbury versus Madison
It stood the test of time.
from, 18 whatever, still governs the United States Supreme Court.
Right.
So some of these old cases can work. And it is interesting, too, that the California Supreme Court disposed of this issue in what is really quite a short opinion.
12 pages.
For a Supreme Court opinion.
Yeah.
I mean, I don't know what the average Supreme Court opinion is for California, but I would have to venture.
I used to know that answer, by the way.
Did you?
Yes.
It's got to be more than 12 pages. And they kind of just dismissed it quite quickly. They also were pointing out some of the counter arguments that the defense was making. And one of them was, well, if you allow this to happen, it would be chaos in the probate court. And I like how the Supreme Court said, well, I think they're overstating it. Because it doesn't allow individuals with no interest in the trust to sue. So you still have to have some arguable interest in the trust to bring a lawsuit.
Well, my argument would be, has there been chaos over the last 10 years? Because this has been the way it's handled over the last 10 years. So,
right. And it's not like anybody can come in and challenge a trust. You have to have some financial interest.
Right. And let's make sure we're separating out these cases. So let's say that someone 3 months before they die, they create a trust for the first time in their life. And there's a beneficiary, there's an heir that's not named in that trust anywhere as a beneficiary. Can that heir sue under this new Barefoot 17200?
Arguably no, because they're not a future beneficiary. They're not even a contingent beneficiary. Because what they're arguing is the trust was created and it cut off my rights as an intestate heir, which would have passed under probate. So most likely, the more proper scenario is you'd have to file something in open probate, an 850 petition, and something like that.
So let's talk about that just for a second. And you file a estate in probate court, and you say, "Hey, this is the decedent's estate here, and somebody wrongly got them to create this trust document 3 months before they died. So what we're going to do is file an 850 petition under the probate code 850, and we're going to reach out and try to claw those assets back from that trust into the estate."
Right.
And there's various grounds that you can use under probate code section 850, really any cause of action you can point to at all on the planet, but it's really a quiet title action where you're going to say, hey, we want to get the title from that trust back into the estate.
If you think about it, because people get confused about this idea that trusts and wills, are they different? Are they the same? In the example you just mentioned, really what you're arguing at the end of the day is the assets shouldn't be distributed under the guidelines of what the trust says. The assets should be distributed under the guidelines of what California intestate law says.
That's right.
And the reason you want that is you're an intestate heir, and you're going to get money. You're going to get money on one side, but on the other side, you're going to get zero. And so when people are asking, are trusts and wills different? Yeah, they're different. They have their own rules, and they have their own procedures that you use to go from start to here's your money beneficiary. And they can even have their, difference of who's going to get the money. Although sometimes it's the same because the will might be a pour over will that gives it to the trust and it's all going to flow through the trust anyway. Or I've seen cases where the will and the trust have the same provisions, but that's rare. And so it's going to be the same beneficiaries. But it is interesting that as an intestate beneficiary or intestate heir, if no trust had been created, you would have received $1 million.
Right.
But 3 days before death, somebody waltzes in, gets this trust created. Now you're going to get zero.
Right.
And so the difference is you can still challenge that. You just have to do it with a different set of procedures.
That's right.
So it's not a different challenge per se.
Right.
So that is the case of Barefoot versus Jennings. Just came out. The opinion just came out today. So it's a brand new opinion.
We'll have more on this, obviously, where we can cite to it and put it up. But
it's authored by Justice Chin.
Yes.
Yeah, and I'm sure we'll have fallout. And, you were making the point, too, of what happens with all these cases, because there have been cases that have been kicked out of court based on the appellate court's rendition of Barefoot,
right.
And now that's been reversed.
Right.
So what happens to those cases?
Right.
Do you refile? Have you blown the statute and you can't refile? What's going to be the result of that?
Well, and I've got a couple cases we have in the firm right now that I cannot wait. I cannot wait for discovery responses from opposing counsel now because of this finding. So.
And this is a published opinion. So, it's published law and we can use it for, going forward. But Good result, right result. I will just share that actually a few years back, 3 or 4 years ago, we had authored a proposed amendment to 17200 to fix this problem. So it didn't just say trustees or beneficiaries. And unfortunately, it didn't go through the committee that reviews these things and ultimately decides whether or not to suggest them to the legislature. It's unfortunate because I think it would have headed off this problem to begin with. The statute is a little funny because the statute under 17200 does say trustees or beneficiaries, and it doesn't have a specific reference to Probate Code Section 24, or it also doesn't have a specific reference to interested persons, which is a broader definition because interested persons includes intestate heirs and those sorts of things. So there could be a lot more fallout from this. There also could be some changes to the legislature in the code based on what happened in Barefoot. So it'll be interesting to see kind of how it plays out.
Right. Well, obviously, with the financial abuse that takes place on elders in California, there's a high percentage of it that happens.
Yeah.
I don't think I'm overstating that. I think many elders are taken advantage of. You want people to have the ability to come to court, have a right to bring that cause of action for a trust contest to the court, and have it determined by the court. Now, if the person bringing it is wrong and the decedent truly intended to have this amendment, it's going to work out that way more times than not.
Right.
Versus maybe 3 months before you die, you then change your pre-existing estate plan, which you've had for years. It gives everything equally to your 3 children, and it gives everything to one child who's living at home with you, who's kept you away from all the other people in your life, including the other 2 children. There may be some questions that need to be answered there.
And now at least we know that we have a forum to at least have that case heard and a decision made. So that's important.
Right. Right.
So, all right.
All right. Thank you.